Hello and welcome to Mourant's Vlog Series. Today I'll be talking about some of the challenges posed by the ownership of private trust companies or PTCs. First of all, what is a PTC? In essence, a PTC is an entity created specially to act as trustee of one or more trusts, usually for one family and usually for estate planning or commercial purposes. Typically, a PTC will be administered by a trust and company services provider in the sense that they will provide the registered office and secretary and sometimes some or all of the directors and help out with the administration of the family trusts. The key point is that the PTC isn't owned by the services provider. Also, the PTC isn't usually required to be regulated or is subject to only a very light level of regulation, providing that another entity that is regulated, most often the service provider, takes responsibility for its compliance with anti-money laundering procedures. Contrast that to a traditional professional trust company. By this, I mean a wholly owned subsidiary of a trust and company services provider that is heavily regulated and not controlled by the family which is seeking to create the trusts. There's been a steady trend towards using PTCs in recent years, especially on higher value structures where they can provide some additional control and or protection for the ultra high net worth client. It's important for any client who is considering using a PTC to know that there are some challenges posed by them which must be carefully considered before diving in and using one. If those challenges are properly addressed, a PTC can add tremendous benefits to the client. If they're not, then risks can inadvertently be created. So what are those issues? Well, they mostly centre around ownership and control, being the very reason why clients or their advisors ask for PTCs in the first place. The point here is that a PTC, like any normal company, must have an owner, and there are various options. One approach is for the family to own the PTC. That has the benefit of simplicity and, of course, with ownership comes control, so on the face of it that might seem the best option. However, most PTCs are established to be trustee of family trusts designed to deal with succession of wealth through generations over the long term. Therefore, if the owner of the PTC is an individual, they'll need to provide for what happens to those shares when they die. That can be done via will, but the disadvantage with that is the probate process can take some time, leaving open the possibility that there will be a period in which control of the PTC will be in limbo. This can be addressed by having different classes of shares in the PTC with voting rights that automatically turn off when a person, normally the patriarch or the matriarch of the family, dies. When those turn off, the voting rights of the other family members turn on. That can work very well, but the drafting can get quite complicated, especially with a large family. A simpler solution is to have another trust own the PTC. This is probably the most common approach that we see. Normally, the other trust is a purpose trust that will continue in existence irrespective of when family members pass away. These specialised purpose trusts are routinely created with professional trustees under the law of the Channel Islands and certain Caribbean jurisdictions, such as Cayman and BVI, whose laws have been specially adapted to allow for them. They deal neatly with the ongoing ownership of the PTC. Purpose trusts can also provide for control over the PTC, for example, by having a third party, which might include the settlor or an advisor close to the settlor, being able to give directions to the trustee of the purpose trust. But some settlors are put off by the extra layer of complexity of having a purpose trust own a PTC, that is, in turn, the trustee of the family trusts. And those concerns should be taken seriously. If an estate planning structure cannot be easily understood by the settlor, it's probably not the right solution. A simpler solution that has evolved in recent times is to have, instead of a PTC, a foundation to be the trustee of the family trusts. Foundations are legal entities with corporate personality like companies, but they don't need to have shareholders. They can be formed in the Channel Islands, and a similar entity type, the foundation company, can be formed in the Cayman Islands. These neatly solve the ownership problem I described earlier and are perhaps easier understood by families, especially those who come from cultures where trusts are less well understood. That's an advantage, but perhaps because foundations are relatively new kids on the block in the Channel Islands and Cayman, they are not yet commonly used in place of PTCs. As I say, the most frequent solution to the ownership problem remains a purpose trust. So, I've said a bit about the ownership of PTCs in this blog, but almost nothing about control. That's another really big subject of its own, so we've made it a topic for a further vlog in our series, so watch this space for more.